throughout my time here, my family has been repetitively denied. I understand Travis Bloom is an idiot. I understand that, fully understand that. He holds a good heart.
Fabricating fictitious government you ever seen.
My little brother used to run to Mother and say, "Mom, BB hit me." BB was my sister. He used to say, "BB hit me." Mom would say, "Well, my lovely young man, where are the marks to prove such?" Well, Mom, show me the marks. He could not show any marks. Mother would say, "I can't tell where the marks are." True story.
And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
I'm sorry, what did you say?
Said
Everybody has.
Oh, okay.
Sorry, just as I was about to start, I saw that there has been an update in the Eduardo Garcia case. The MSP recruit who passed away after a training exercise. Remember, we covered it, I believe, last year, maybe. No, it's been more than a year, I believe. The young man who passed away doing a training exercise, and they had a specially appointed, not prosecutor, but they had someone who had to look into the case, and there has just been a press conference today where, well, I know I said Kelsey Fitzsimmons, but let's give this a look as well, because this is fresh off the press. So
Good afternoon, everyone. Thank you for being here. On September 13th, 2024, Massachusetts State Trooper Enrique Delgado Garcia died while training to become a Massachusetts State Trooper. He sought to become a state trooper to fulfill his dream of serving and protecting the people of the Commonwealth of Massachusetts. Shortly after Enrique's death, and after consultation with Worcester District Attorney Joe Early, I appointed an independent investigator, Attorney David Meyer, to review the facts surrounding Enrique's death. I want to thank Enrique's family, his friends, his fellow trainees, and the public for their tremendous patience as this process unfolded. I know that to some, this process has felt long and opaque. Independent investigations are careful and thorough by necessity. In order to maintain the integrity of their process, certain aspects cannot be shared with the public. That confidentiality is by design to ensure fairness for everyone involved. Enrique was a public servant. He began his career in the Worcester District Attorney's Office as a victim witness advocate. His family has spoken openly about his intention of being someone who made a difference in the community and his dreams of becoming a Massachusetts State Trooper. He was a son, a brother, an uncle, and a friend. And Enrique should be alive today. Given the extraordinary nature of these events and the complexity of this case, it was necessary to appoint an independent outside investigator. Death investigations are typically handled by the local district attorney. In this case, however, Worcester DA Joe Early appropriately determined that his office had a conflict because Enrique worked in his office as a victim witness advocate. Following conversations with DA Early, we determined that Enrique and his family deserved an investigation that was completely impartial and devoid of any perception or appearance of conflict. That's why I appointed Attorney Meyer. Attorney Meyer has extensive experience both as a prosecutor and a defense attorney, including 12 years in the Suffolk County District Attorney's Office, where he supervised, investigated, and prosecuted death investigations within Suffolk County. He has since served as partner at Todd & Weld. In this case, David investigated the facts of Enrique's death and the circumstances that surrounded it, just as my office or any other district attorney's office and its investigators would have done. My office was briefed about the investigation along the way and provided logistical support. Because of the design of the investigation, Attorney Meyer had his own independent team to conduct the investigation, and he had full autonomy in making investigatory and charging decisions in this case, which he will discuss shortly. I am grateful to Attorney Meyer for his thorough efforts to follow the facts and to seek accountability to those responsible for Enrique's death. In no way is this investigation and the charges it has yielded a condemnation of all law enforcement. The men and women who choose to serve, protect our communities, often in difficult and dangerous circumstances. Our law enforcement members, including those who serve in my very office, are essential to public safety and the rule of law. I know just how much the Commonwealth benefits from the men and women in uniform who serve the public because I see it up close every day. Many officers go beyond their law enforcement jobs, mentoring young people, supporting community programs.
Maybe not talk about mentoring young people right now in Massachusetts after Sandra Birchmore and that officer who abused his position to get information on a 17-year-old girl.
Actively working in our communities in a very challenging time to build trust. Their service deserves respect and recognition. And just as they protect us, it is our responsibility to ensure that our aspiring officers at the Massachusetts Police Training Academy are protected from preventable harms and to seek accountability when serious incidents occur. There is nothing more serious than the loss of a life. We can both honor the men and women who serve while also still ensuring accountability within a system, especially when someone dies. Lastly, while Attorney Meyer's investigation focused on Enrique's death, there must be serious discussion and action with respect to reforms. I know that the State Police Colonel, Jeffrey Noble, has already undertaken efforts to effectuate change, and I'm grateful to him, and I look forward to supporting him in those endeavors going forward. Because this is an ongoing legal matter, there may be some questions that I cannot answer in order to preserve the integrity of Attorney Meyer's case. We appreciate your continued patience, and at this time, I'd like to turn over the podium to Attorney David Meyer.
Thank you, Attorney General Campbell, and good afternoon. On the day that I was appointed as independent counsel, I made a commitment to the family of Enrique Delgado Garcia, to the Massachusetts State Police, to the public, and to the criminal justice system, that I would conduct the investigation professionally, thoroughly, and independently. I pledge to follow the facts and the law, to perform my work conscientiously and responsibly, and to exercise my independent judgment to reach whatever results the facts and the law dictated. I committed not to permit the speed of the investigation, the length of the investigation, or any other outside factors to influence the investigative process. I owed that to the family of Enrique Delgado Garcia, to the Massachusetts State Police, to the public, and to the criminal justice system. When Attorney General Campbell appointed me, I knew nothing about the facts surrounding Enrique Delgado Garcia's death or about the State Police Training Academy. I had no preconceived notion of the potential outcome of the investigation. With the support of an independent investigative team, my assignment was to gather the facts through any and all available investigative means, taking as much time as we needed to do things the right way, and to follow those facts and the applicable law wherever they may lead. I fully recognize that the investigative process has been lengthy and it has been conducted in silence, without public comment, at least on my part. That silence has been purposeful. It is a direct reflection of the nature of the investigation and of my ethical and legal obligations. At the same time, I can assure the public that the investigative process has been searching, it has been exhaustive, and it has been without outside influence. Given some of the challenges posed by the investigation, early last year, I sought judicial approval from the Chief Justice of the Superior Court to impanel a special statewide grand jury in order to conduct an independent fact-finding investigation into the circumstances surrounding the death of Enrique Delgado Garcia. The impanelment of a special statewide grand jury enabled us to compel the testimony of witnesses, to memorialize testimony under oath, to subpoena relevant documents and information, and to gather the facts in a formal proceeding before an independent body. At each stage of the process, the investigative team and I met with the family of Enrique Delgado Garcia to update them on the status of the investigation. We met with the family this past weekend, and we spoke to them this morning. Over the course of the past 9 months, the grand jury has heard sworn testimony from over 150 witnesses, the vast majority of whom have been state police officers. And the grand jury has reviewed close to 350 physical exhibits, the vast majority of which relate to policies, procedures, activities, and events at the State Police Training Academy. The evidence gathered by the special statewide grand jury has revealed that in the days and weeks prior to September 12, 2024, members of the State Police Training Academy committed a series of wanton and reckless acts in connection with various defensive tactics and physical confrontation training exercises conducted at the academy.
So, all of that BS we were fed about, he just fell and hit his head, is what it is. It's just BS.
The facts and circumstances underlying the wanton and reckless conduct include both A, affirmative acts by Academy staff, and B, the failure of Academy staff to take certain actions or omissions that they had a legal duty to perform during their daily interactions with the trainees, who were under their care, guidance, and supervision. The wanton and reckless conduct resulted in Enrique Delgado Garcia suffering concussion-like symptoms as the result of unauthorized, unapproved, and unsupervised boxing-related sparring exercises that occurred during Academy training activities on Wednesday, September 11, 2024. The wanton and reckless conduct culminated in Enrique Delgado Garcia suffering multiple blunt force injuries to the head and massive brain bleeding as the result of the failure of Academy staff to intervene and bring a stop to a competitive boxing match between Mr. Delgado Garcia and a fellow trainee that occurred during Academy training activities the following morning on Thursday, September 12, 2024. Mr. Delgado Garcia died the following day, September 13, 2024, as a result of the head injuries sustained during the recruit-on-recruit boxing match that Thursday morning. Based upon the facts and the law, the evidence gathered by the grand jury compels criminal prosecution of certain members of the Academy's Defensive Tactics Unit, the supervisor of the unit, and 3 full-time instructors. These individuals engaged in ongoing interactions with Enrique Delgado Garcia on September 11, when he suffered concussion-like symptoms, and on September 12, when he was knocked unconscious. These individuals also had direct management and direct control over the physical training exercises themselves. Factually and legally, each of these individuals owed a duty of care to Enrique Delgado Garcia and to his fellow trainees. Each of them interacted.
Yeah, ongoing interaction. So I think we heard something about hazing rituals that might have gone wrong or gone too far at the police academy. If he already suffered concussions the day before he passed away, this shows you these people shouldn't have had that job.
Acted with Mr. Delgado Garcia and his fellow trainees on a daily basis, and each of them committed a series of wanton and reckless acts and omissions that resulted in Enrique Delgado Garcia's death. Given their roles and responsibilities on the Defensive Tactics Unit and their control over the training exercises, the wanton and reckless conduct committed by these individuals violated 2 criminal statutes in particular. General Laws, Chapter 265, Section 40, alleging the crime of causing serious bodily injury to a person participating in a training program involving physical exercise, and General Laws, Chapter 265, Section 13, alleging the crime of involuntary manslaughter. In addition, the evidence demonstrated that when the supervisor of the Defensive Tactics Unit was asked specifically under oath before the grand jury when it was that she first learned about Enrique Delgado Garcia's concussion-like symptoms, she repeatedly responded falsely. Given the circumstances of this investigation and the nature of the information at issue, her testimony before the grand jury violated General Laws, Chapter 268, Section 1, alleging the crime of perjury.
Jesus fucking Christ. You're cops, for God's sake. Can't you be truthful? What's wrong with Massachusetts? Even the cops make perjury. I'm sorry, Massachusetts, I feel sorry for you.
Now, each of these charges are merely accusations. Each of these individuals is presumed to be innocent unless and until proven guilty in a court of law. These individuals have not been and will not be arrested. I have requested that the court issue a summons for their appearance at an arraignment hearing to be scheduled in the near future in coordination.
She lied in front of the grand jury repeatedly about when she was informed about his concussion-like symptoms.
With the court and with their individual attorneys. With respect to each of these charges and each of these individuals, I have intentionally not referred to any of the specific underlying facts that were gathered and considered by the grand jury. Given my ethical and legal obligations, this is neither the appropriate time nor place to do so. Given the paramilitary structure of the State Police Training Academy, various members of the Academy command staff have the authority and the ability to address many of the circumstances surrounding Enrique Delgado Garcia's death. At the same time, the evidence before the grand jury demonstrated that the nature and extent of their personal knowledge, personal involvement, and personal participation in the specific acts and omissions that resulted in Enrique Delgado Garcia's death were insufficient to support criminal charges. Based upon the evidence, a reasoned and responsible evaluation of the facts and the law does not support criminal prosecution of members of the Academy's command staff, nor does my professional respect for and commitment to the rule of law. Insofar as I have shared with you generally that certain wanton and reckless acts and omissions compel the criminal prosecution of certain members of the Academy's Defensive Tactics Unit, I want to ensure that certain additional facts are made abundantly clear. Based upon the testimony and the exhibits before the grand jury, there is no evidence that Enrique Delgado Garcia was targeted in any way. There is no evidence that anyone, Academy staff, fellow trainees, or any others, harbored any personal animosity towards Enrique Delgado Garcia. There is no evidence that anyone acted with deliberation, premeditation, or malice. One final comment. I take no personal.
So they were just shitty cops. They didn't intend to do it, and it just happened. Cops covering cops again.
Personal satisfaction, none, from where these facts have led. But I am confident that the investigative team and I have carried out our assignment professionally, responsibly, and independently. And I am confident that we have done so the right way and for the right reasons. Thank you.
Thank you, Attorney Meyer. I'm happy to take a few questions.
Attorney General, a comment on the trainee who was involved in this Boston exercise. Any consequences for this investigation?
Not in this investigation.
And when it comes
And
to...
I will just share what's being shared right now from the team is more detail on the charges and those who the charges are being brought against.
And Attorney General, when it comes to this investigation with the cost reaching $700,000, can you speak to the taxpayers on that investment and the results that were shared today?
So my job in this case, given the conflict that existed for DA Early, was to ensure that the family got an independent investigation that would be thorough, that would be handled well, with integrity, a standard of excellence, and devoid of any conflict or appearance of conflict. By reputation and integrity, David was one of the folks I considered and ultimately hired him knowing he would do a thorough job. A thorough job in following the facts, the law, and of course reporting to the public where appropriate where his investigation has led, which he's done today. He gets nothing out of this. He charged below market rate to ensure that a thorough investigation was done, and that's exactly what happened here, and that's what the family deserved.
Do you expect there to be any kind of report issued about non-criminal findings? Like Attorney Meyer mentioned, that there might not be cause to prosecute other folks, but just do we get more information about what all was going on?
So it's an ongoing investigation, and as it unfolds, Attorney Meyer, and where appropriate, either together or separately, will continue to update the public on what can be shared. It's obviously an ongoing investigation, so we have to be extremely careful. That being said, Attorney Meyer was tasked with an independent investigation to look into the facts and the circumstances surrounding Enrique's death, and that is what he has focused on. In addition to that, I also think it's equally important that the administration, EOPS, MSP, which I know Colonel Noble is already doing, look at reforms to bring about. I know that is underway, and I fully support the Colonel in those endeavors as they go forward. And of course, as more becomes public and able to share, I will do that.
What is the current status of these troopers? Are they currently on the force, or are they on the...
That's a question for MSP.
Are you able to share where they will be summoned and who will be taking over the case or who will be leading the case?
The indictments were just unsealed this morning, and as I indicated, we just had an opportunity to meet with the family over the weekend and again this morning, and the court process will then undertake, and as I said, I've been in contact with counsel for each of these 4 individuals, and we will coordinate with the court to schedule an arraignment hearing in the near future.
David, can you expand a little bit on the perjury charge? What I know you can't go into too many underlying facts, but how serious is that in your mind, a sergeant committing a perjury on this?
Well, I'm not going to offer any of my personal opinions, respectfully. I think I outlined within my ethical and legal parameters and obligations what the allegations are, and everything else will play out in court.
Agent Campbell, how about you? Do you want to comment on a state police sergeant committing perjury allegedly in this case?
I would just echo what Attorney Myers echoed to ensure that this case continues to unfold, respecting the rights of all involved, and of course due process. More will be shared as it unfolds in the courts, and he will share more when that's appropriate.
That's the last question, guys. Thanks, everyone.
I don't know. I don't know if I should laugh or I should cry. 4 officers has been recommended by the grand jury to be indicted. One of them for perjury in front of the grand jury. And yeah, we'll send them a letter. That's fine. A man died in their care. A man who was trying to become a police officer. And they are just, yeah, we'll send them a letter. They can just show up to court. It's, imagine if this had been when streamers met in a parking lot and one of them got beaten to death. Do you think they would have been treated this way? Not named on the scene. Not have the charges against them other than the perjury charge mentioned. Massachusetts needs Adam Deitch. That's the first brick to be pulled out of that wall. That is a disgusting way Massachusetts is run. So they knew he had concussions or concussion-like syndromes the day before. And then they still sent him into a boxing match the next day. I believe there was a Super Bowl yesterday. I believe they have very severe concussion protocols. So if there's any suspicion that you have taken a hard hit to your head, you will be checked by a doctor, and you'll have to sit out if they. Did you notice that she went over there and she kind of dried her eyes? Yeah. Well, that was one part of Massachusetts that is a hellhole. Then what we were really supposed to gather here today for is the motion that was filed in the Kelsey Fitzsimmons trial. Oh, another shitty judge, if we are to believe the defense. Happened to a Seagulls player in yesterday's game. Oh, I was watching it, but it was so boring I didn't do it. Not the MSP. The entire justice system in Massachusetts is rotten. The judges, the prosecutors, the police officers. There are so many bad eggs out there. Even the trainers at the police academy are rotten. Living here, we have seen it for a long time. It's not just Norfolk County, the whole state's in trouble. Yeah, and sadly, the people who decides who you get to vote for don't care. They will give you exactly who they want to see in power because that's their prerogative. They don't give a fuck about you. They don't give a fuck about the shitty judges, the shitty police officers, the shitty prosecutors. They just want power. And I don't give a horse's ass if they are red or blue. That's not what I'm talking about. I'm talking about politicians who will put people in positions where they can do what the hell they want as long as they play the party line. Red, blue, whatever. This is, you can say everything you want about our system where 15 different political parties run, and that might seem extremely chaotic. But it also ensures that we have a lot more influence across the line. Even if the red win, the blue will still have some influence because it's proportional. That's the biggest problem with having a two-party state. It's just one more party than a one-party state. And as we all know, one-party states are shit. Communism, fascism, were all one-party states. It's never good. Power corrupts. Ultimate power corrupts ultimately. This can't be the first time the Academy have gotten away with this behavior, in my opinion. Well, probably the first time someone died there. But I think when this broke, there was an article about they had a very high dropout rate of police cadets. So, yeah. Yeah, I talked about that Saturday, I think. And if he gets his way, and he most likely, this is the scary part, because we're 200 people here today. I bet maybe 100 are from Massachusetts. You all know it's shit. But if you go to your hairdresser tomorrow and say, who are you going to vote for? I don't know. I'll figure it out. Because they don't care. They're just going to go there and then they're just going to, oh, I heard Morrissey, and Morrissey has been elected forever. He must be right. 83 to 87% of people will vote exactly the same way they did at the last election. That's just basic facts. Unless you have, in Denmark, we call them earthquake elections. That's where everything just blows up and one party just gets 15, 20% of the votes that no one expected. But every other election, 83 to 87% will vote exactly like they did the last time. Even people who hate what the politicians are doing are going to vote exactly the same way because that's what we always did. In Denmark, we say that's what daddy did because you are born in two parties. Massachusetts is Argentinian levels of human corruption. They just lack the inbred red state thing we have up north. I don't want to put a political political color on it because there's wonderful Democrats, there are wonderful Republicans. The problem is power. It's not the color of your party book. It's the power you get access to and the power you want to have. That in Denmark, everyone we know unless they call a snap election, we're probably going to get that because our prime minister just had a big jump in the polls. So we're probably going to get a snap election soon. But other than that, we know when we're voting for city council and for we have city and then we have county and then we have country, and we are voting every 4 years. We are voting for city and county on the same day, and it's always this day. So you know, okay, that day, that's election day. It's a Tuesday. Almost every time it's a Tuesday, and then everyone goes. It's actually been dropping in Denmark as well. My polling place, the last time I was there, I think we were like 73% voted. So, but again, they don't want to do this, Stephen, because that would take away their power. They want a low turnout because who goes to vote on election day if it's not something everyone does? Party soldiers and angry people. So you just need more party soldiers than you need angry people, and you can determine who runs your state. Yes, I did say a snap election. It's where you know, in 3 weeks we're going to have an election. We're supposed to have it in November, but we need an election now because her numbers are climbing. How many parties are there in Denmark? Well, represented right now in the national government, I think we have, I want to say 12 in the national government. Enhedslisten, Alternativet, SF, Socialdemokratiet, Venstre, Konservativ, Dansk Folkeparti, Nye Borgerlige, Liberal Alliance, Moderaterne, Danmarksdemokraterne. No, 11, maybe 12. Oh, yeah, Borgernes Parti. Yeah, we have 12 parties right now in our national government. My local government, we have 6 or 7 different parties. No, you're wrong. Enhedslisten, Alternativet, SF, Socialdemokratiet, Moderaterne, Radikale, dem glemte jeg før, Venstre, Konservativ, Liberal Alliance, Dansk Folkeparti, Nye Borgerlige. Ej, de er jo teknisk set ikke derinde mere. Borgernes Parti teknisk set heller ikke derinde mere. Og Danmarksdemokraterne. I hvert fald 11. How do you just say there is an election? Don't you have set days? No, we have a thing that's called, you have 4 years, but the government you have what's called Folketing. That's like your Congress. Out of the Congress, parties go together and then they need more than 50% of the votes. They will then become the government. They are the ones who run run the shop, and the rest are the ones who try to annoy them. The government can never, ever have a vote where they don't have the majority of the votes going for their proposal. If they do that, they have lost the popular support, and they will then have to make an election. Normally, if you can see, oh shit, we're going to lose this one, they'll just pull it, so you don't get to vote on it. But sometimes you will go in and say, this is so important, I am willing to take an election on it, because it's normally something about taxes up or taxes down. And you'll lose it, and then you can go run a election campaign. Elections must be 3 weeks after, I think, at least 2 and not more than 4 weeks after they have said that we're going to hold an election. But a government in Denmark can maximum be there for, there can maximum be 4 years between elections, but they can call an election every single day in those 4 years if they want to. Then the government shuts down 3 weeks, 4 weeks after we will have an election. And then there would be a new government who will then form. The king will approve it, and they will run the shop. Stephanie, let's not pop the champagne so far. Sweden got 3 elections. We do them all at the same time. Ain't risking meeting people more than that. Yeah, well, we can't do it because the Folketing can do it whenever they want. And then every 5 years you have EU as well. No, Starmer hasn't stepped down yet. It's been rumored since Friday that he's gonna step down. You should. Remember, I did start out as a political channel. And I remember 13 parties were running in the election because I had 14 interviews, but only 12 parties represented because that son of a bitch from Socialdemokratiet didn't show up. Enough about Danish politics. We'll have to see what the charges are against these people. One of them will get perjury charges. Is the King of Denmark even a real king? Yes, he's such a real king that he actually spent time in our Navy SEALs, which is called the Frogmen. And he's a cool guy. I have drunk beer with him. Defendant's motion to recuse Judge Kelsey Macarthy-Neyman and request for evidentiary hearing. Now comes defendant Kelsey Fitzsimmons. Blah, 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 blah. As ground, and hereby files an instant motion to recuse Judge Kelsey Macarthy-Neyman. As ground, it is apparent that there's a reasonable disinterested observer, being appraised of the facts of the judge's involvement in the case would conclude that there is a lack of impartiality, or at a bare minimum, an appearance that the judge's impartiality might reasonably be questioned. The instant motion is made pursuant to the due process clause of the 14th Amendment of the U.S. Constitution, Article 29 of the Massachusetts Constitution, Declaration of Rights, the provision of the Supreme Judicial Court's Code of Judicial Conduct, and applicable case law, all of which mandate disqualification when a judge cannot be fair or impartial, or where her impartiality might reasonably be questioned by a disinterested third party. Here, the record demonstrates multiple grounds, each independently sufficient and collectively dispositive, requiring recusal. Remember, they already tried to have her recused because of the way she acted at the bond hearing, where she just stood up, left the room. That was where we started. Well, it happens all the time. Request of evidentiary hearing. As the body of evidence required to be amassed in support of this motion likely includes but is not limited to probation officials, municipal third-party records, social media information, and the like, an evidentiary hearing at its attendant subpoena power is necessary to introduce the evidence and make sure the record is clear. Or the record? Applicable standards. A judge must disqualify himself in any proceeding in which a reasonable person, knowing all the circumstances, would question the judge's impartiality. The inquiry does not turn on the judge's subjective belief in his own neutrality, nor does it require a showing of actual bias. This principle of impartial justice is enshrined in Article 29 of the Massachusetts Constitution Declaration of Rights. It is essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the law and administration of justice. It is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. A rigid adherence to that principle is essential to the maintenance of free institutions. It may never be relaxed. Tomajanian versus Orabshian, maybe. In fact, litigants and visitors to the Supreme Judicial Court at the John Adams Courthouse in Boston are greeted with one legal principle, to the exclusion of all others. In the vestibule, the words of Article 29. The protection of an accused's rights to an impartial adjudicator is prominent in both the United States and Massachusetts constitutions. See Caperton versus A.T. Massey Coal Company. It is axiomatic that a fair trial is in a fair tribunal is a basic requirement for due process. Actual impartiality alone is not enough. Our decision and those of the Supreme Judicial Court have commented often and in a variety of contexts on the importance of maintaining not only fairness, but also the appearance of fairness in every judicial proceeding. Com v. Morgan R.V. Resorts, LLC, quoting adaptation of TIA, in the words, an accused's constitutional right to due process demands that justice satisfy the appearance of justice. Ufud v. United States. In ruling on a motion seeking recusal for an actual, apparent, or potential transgression on Article 29 and the Code of Judicial Conduct, a judge must consult first his own emotions and conscience. If he passes an internal test of freedom from disabling prejudice, he must next attempt an objective appraisal of whether this is a proceeding in which his impartiality might reasonably be questioned. Commonwealth v. Eddington. Quoting Lena v. Commonwealth. If the answer is positive, the judge must grant the recusal motion regardless of such consequences as trial delay, which are immaterial. Patano v. Jacobson. See Code of Judicial Conduct, Rule 309, which in pertinent part provides a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned. A judge is disqualified from any matter if the judge cannot satisfy both the subjective and the objective standard. The subjective standard requires disqualification if the judge concludes that he or she cannot be impartial. The objective standard requires disqualification whenever the judge's impartiality might reasonably be questioned by a fully informed, disinterested observer, regardless of whether any of the specific provisions of paragraph A1 through 5 of Rule 2.11 apply. Specific non-exhaustive examples of bias. The standards focus on public confidence in the integrity of the judicial process before the court. Commonwealth v. Dane Entertainment Services, Cafaloo v. Globe Newspaper and Co., Edinburgh v. Cavers. Recusal is required where a judge has a personal or economic interest that could be substantially affected by the outcome, has engaged in ex parte communications concerning a pending matter, has become personally embroiled with parties, counsel, or witnesses, or has taken actions that viewed together undermine the appearance of impartial adjudication. See Supreme Judicial Court Rule 309. Code of Judicial Conduct Rule 211, 1-5. All of these recusal categories are present in this case. Oh. Procedural background relative to recusal. Ms. Fitzsimmons is before the Essex Superior Court sitting at Salem in a one-count prosecution charging assault by means of dangerous weapon under C-265, paragraph 15b(b). Judge Macarthy-Neyman presided on the case on August 14. Is it really that long it's been going? For a bail petition in Essex Superior Court on August 28. for arraignment, September 9th for a bail hearing, and September 11th for emergency motion for immediate relief from scram. On both August 14th and on August 28th, Judge Macarthy-Neyman was assigned to Salem Civil A Courtroom H, handling civil business in Salem Superior Court. The judicial assignment sheet for August 2025 attached as Exhibit 1. It's just a spreadsheet or a sheet over where she is. Nonetheless, she appeared and handled both the bail petition and the arraignment in the criminal session without any verbal or written explanation in court or on the docket. That's weird. Kind of like Bev assigned herself to the Karen Reed case. The assignment sheet for September 2025, attached as Exhibit 2, also reflects her assignment to the same civil session. Nonetheless, she continued to leave the civil session and handle criminal business in Mrs. Fitzsimmons' case without explanation. And if you want to, I can show you. It's just a long list of names where you can see where they were supposed to be. So this is where they're supposed to be that day. That's not highlighted on that one. Exhibit 2, where you can see who are assigned to criminal courtrooms that day. So she apparently put herself into this case. Without notice to the parties or the public, it appears she has specially assigned herself to this case, a one-count simple 2 or 3 day trial where a conviction warrants only a sentencing guideline sentence of straight probation. The assignment seems inexplicable on the merits of the case and raises questions about the motive of the court so as to undermine the public's confidence in an ongoing adjudication. So again, what's wrong in Massachusetts? Kelsey Fitzsimmons, if she gets convicted in this case, would, according to all the guidelines, get probation. And she spent how long in prison? Because this judge apparently put herself on this case and fucked everything up. Grounds for recusal. Prejudgment reflected in a dangerousness finding and other pretrial matters. In upholding prior dangerousness findings and herself finding Ms. Fitzsimmons dangerous under Rule 58A, the judge has been privy to and has adopted a fact evidence that would not come into a trial of the underlying charge. The court has made a subjective personal finding that Ms. Fitzsimmons is a dangerous person. She has repeatedly referenced her belief necessarily by clear and convincing evidence that Ms. Fitzsimmons is an ongoing and present danger to her assailant, Officer Noonan, who needs the protection of a dangerousness finding from her. The court has also gone so far as to explicitly prevent any potentially favorable family court custody or visitation orders by prohibiting Ms. Fitzsimmons from seeing her infant child, regardless of any custody determinations in that court. This is a highly unusual finding, unprecedented in undersigned counsel's experience, that a superior court judge would impair the family court in performing its own core function of determining custody and visitation in the first instance. This court has gone far out of its lane in an effort to keep Ms. Fitzsimmons from her infant, which will be the biggest crime in all of this. The court's finding in these areas amount to an expression of her opinion on the character and guilt of the defendant. There are several relevant legal guideposts for the proposition that a judge who makes adverse pretrial findings on a case should avoid sitting as the trial judge. In Parento Supra 32, Massachusetts, Appendix CT 97, the trial court's findings that the defendant was untruthful in the past and its failure to recuse at the jury trial was found to be an abuse of the discretion by the appeals court. The appeal court found his actions constituted error because if, after applying the two-parts test of SJC Rule 3.9, Canon 3, C1, a judge finds that he should disqualify himself under either part, he must allow the motion. Possible consequences of his recusal on the commencement of the trial are immaterial. Further, a judge cannot partially recuse himself. Once a judge concludes there are grounds for recusal, he must completely disassociate himself from participating in the case. Ordering a jury trial, as the judge did here, does not substitute for allowance of a recusal motion. Even if he is not the fact finder, a judge presiding at a jury trial performs important functions. See Commonwealth v. Wilson, quoting from Whitney v. Wellesley and Boston. The judge's role at any trial is to be the direction and controlling mind at the trial, and not a mere functionary to preserve order and lend ceremonial dignity to the proceedings. Obviously, during the course of a jury trial, a judge, by exercising his discretion on various matters, makes important decisions which may affect the verdicts returned by the jury. Therefore, a courtroom has no place for a judge whose impartiality in a matter may be reasonably questioned, even if he is not the fact finder. We vacate the judgment and remand the case to the housing court for a new trial. In parentero, the court's pretrial findings regarding untruthfulness of a party were dispositive for recusal from the trial, and selection of a jury trial was not a remedy. The foregoing findings against Ms. Fitzsimmons are equally dispositive for recusal and are further supported by the present court's comments against counsel. Here, in its order dated September 16th, document number 19, this court has alleged that defense counsel did not transparently provide information resulting in a manipulation of the courts relative to defendant's physical condition. The defense believed the court possesses extrajudicial ex parte information that are speculative, misleading, or incomplete that drives this assertion. In any event, no such extrajudicial information has been disclosed by the court, nor has there been an opportunity for the defense to respond, which is required by the Code of Judicial Conduct, see Section 2.9a, relative to disclosure of ex parte communications. See also infra-section addressing ex parte communications with probation concerning a pending matter. Oh my God. As always, it's a lot of shit. The defense denies the claim and has not had any opportunity to address it. In any event, the court's personal conclusion in this regard gives the appearance as well as the actuality of partiality on the part of the court requiring recusal, as was the case in parentero. Any other result would be an absence of discretion. Comment 3 to Rule 2.6 of the Code of Judicial Conduct also addresses similar circumstances where a judge is exposed to settlement or plea discussions and states, judges must be mindful of the effect settlement or plea discussions can have, not only on their objectivity and impartiality, but also on the appearance of their objectivity and impartiality. Despite a judge's best effort, there may be instances where information obtained during such discussion could influence a judge's decision-making during trial, and in such instances, the judge should consider whether disqualification might be appropriate. See Rule 2.11 asterisk in original. Adverse findings in a 58A context involve the same negative connotation as partiality against defense counsel, plea, or settlement discussion, and should be included in the same calculus for the sitting judge on both the subjective and objective prongs as to whether an appearance of bias exists. Similar, the reporter's notes to Massachusetts R. Crime P30 relating to post-conviction relief address whether the trial judge who preside over a defendant's conviction should continue on the matter. While in the first instant, the case should start with a trial judge, the trial judge may bring to the hearing a prejudice that another judge would not have. Recusal of the trial judge should thus be liberally exercised, particularly where it is requested by the moving party, the American Bar Association Criminal Justice Standards. Reporters notes to Massachusetts Crime P30, thus the rule recognizes that prior findings and proceedings can taint objectivity and that recusal should be liberally exercised, especially where the moving party requests it. Exactly the same we just said. The court's prior findings relative to the character and fitness of the defendant as a mother, as well as the court's criticism of defense counsel, conclusively demonstrate that the court's objectivity is tainted, warranting recusal. I will tend to agree with this man. It's my ex-party and I cry if I want to. Good one, Zach. Finally, the court's demeanor and action at September 11 pretrial hearing also provide ample ground for recusal. Rule 2.3 of the Code of Judicial Conduct provides a judge who manifests bias or prejudice or engage in harassment in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. A judge must avoid words or conduct that may reasonably be perceived as manifesting bias or prejudice or engaging in harassment. The recording of the hearing accurately preserves and demonstrates the court prejudiced demeanor and actions and should be grounds enough for the court to step off the case. On appearance grounds, the defense would admit a copy of the recording at the recusal hearing. Where did I miss a footnote? Oh, it's up here. If by rule or practice ordinary assignment to the same judge is adopted, there should be a declared policy permitting the judge freely to recuse himself or herself in a particular case, whether or not formally disqualified. The Massachusetts legislature also has recognized through passage of GLC 218 Sec 26A that a judge who considers prior adverse findings against the defendant through plea negotiation should not sit on a trial for the same litigant. Chapter 218, 26A provides that in the district and Boston municipal courts, at the option of the defendant, the trial may be before a judge who has not rejected an agreed recommendation or dispositional request made by the defendant pursuant to the provisions of Section 18 of Chapter 278. Review in such case may be had directly by the appeals court by appeal, report, or otherwise in the same manner provided for trials of criminal cases in the Superior Court. The legislature has provided a blanket veto to the defense where such information has been tendered pretrial. In the circumstances at bar, a judge who has rejected the defense request for release and found her dangerous and unfit, it's harsh words, sitting in pretrial judgment of a defendant should not handle the trial of this matter. Judge Macarthy-Neyman should recuse herself from the trial and any further substantive pretrial proceedings. Findings of dangerousness and parental unfitness, when viewed in conjunction with ex parte communication, personal accusation against counsel, and the judge's own extrajudicial interest, all combine to demonstrate that this court has prejudged critical issues central to the case. Continued participation might cause a reasonable observer to doubt the judge's ability to approach subsequently proceedings impartiality. Personal and economic interest creating appearance of bias. Oh, that's interest. Oh. That's what? Basic internet research showed that Judge McCarthy has resided in the town of North Andover for approximately 25 years. Public real estate records indicate she is a listed homeowner in the town. She was the founder and principal of the law office Kathleen M. McCarthy, a criminal defense firm in North Andover, Massachusetts, and is listed in Massachusetts Lawyer Weekly, April 29, 2020, as a former sole practitioner in North Andover. And I know it's Massachusetts, so it's probably North Andover or some weird way of saying it. From 1997 to 2018. In adjudicating the alleged dangerousness of Ms. Fitzsimmons, a fellow North Andover resident, in a North Andover incident, the court inevitably had to consider the safety of herself, her own family, and former colleagues that work and live in the town. As a taxpaying resident, the judge has a vested interest in the financial security of the town and its reputation of the Commonwealth. I'm sorry, that's a bullshit argument. That won't fly. On the unique facts of this case, one North Andover police officer, Patrick McCarthy-Neyman, discovery document provided by the Commonwealth relative to Noonan's training list. His full name is Patrick McCarthy-Neyman. It is unknown and undisclosed by the court whether there are family relationships. Patrick McCarthy-Neyman shot and almost killed another North Andover police officer, defendant Kelsey Fitzsimmons. The police immediately adopted and believed the story of the shooter officer and never sought to interview Miss Fitzsimmons, who fought for her life for 53 days in Massachusetts General Hospital. The case involves only these two officers as recipient witness with no body camera video. The defendant has potential civil claims arising from the conduct of governmental actors in this case, claims that could foreseeably expose North Andover to substantial financial liability. Municipal tort liability directly implicates municipal finances and taxation, and as a resident property owner, the judge has an economic interest that could be affected by the outcome of this criminal trial. I don't think that will fly. Such an interest is disqualifying where it might cause a reasonable observer to question impartiality. I don't think that that's a good argument. Andover. Is it Andover? Don't say that. Another Essex Superior Court judge, Kristen Buxton, recused herself in a similar circumstance as a taxpayer in the town of Ipswich, or as they call it in Massachusetts, Ipswich, in the matter of Copythorne et al., the town manager of Ipswich. Copythorne was a taxpayer sued under GLC 40, Rule 3, and Judge Buxton, an Ipswich taxpayer, recused herself, noting an appearance of impropriety. Seeking to ensure the greatest possible public confidence in the court's independency and impartiality, she recused herself due to her ties to the town. She stated, "The Code of Judicial Conduct, Supreme Judicial Court Rule 309, sets forth that judge should avoid both impropriety and the appearance of impropriety. This is to ensure the greatest possible public confidence in their independence and impartiality. As I am a property owner in the town, despite no actual conflict, there may be an appearance of conflict." Then it might actually work because this is a judge who have said that before. Interesting. The appearance of impartiality is compromised when a judge sits in judgment over a case where the outcome may affect her own municipality's financial exposure. Judge Macarthy-Neyman should mirror Judge Buxton's decision in Copythorne and withdraw to avoid the appearance of lack of impartiality. Ex parte communications with probation. Sorry. I'm 2 for 2 on town names. Yes, sirs. I don't know if it's a strong argument, but there is a judge who have done it before, which kind of sets a precedence that judges should do it. So I don't know. I don't know. So yeah. I'm not a lawyer. I don't know what, but I just don't. Before I read that this other judge has recused herself on the same grounds, I thought that was kind of a stretch to go there and say, hey, because you pay taxes, then a judge could never sit because you'll pay state tax as well. Ex parte communications with probation concerning a pending matter. Undersigned counsel has recently been informed that Judge Macarthy-Neyman had an ex parte and undisclosed conversation with Assistant Chief Probation Officer Jeff January, ACPO January, on September 10th. This conversation occurred the day before the court sua sponte revoked Ms. Fitzsimmons' bail and returned her to custody. Cut off defense counsel invited objection from the Commonwealth walked off the bench when counsel was addressing the court, vilified ACPO January in open court, and was visibly shaking and angry. Counsel was informed by ACPO January and his attorney that Judge Macarthy-Neyman came to his office unannounced the day prior to this hearing. Why is a judge doing this? That's to me, that's highly inappropriate. She sought to investigate the status of Ms. Fitzsimmons' compliance with probation terms and was informed by ACPO January that there was no violation, which makes it even more sus that she then puts her in prison the next day. Because she was informed there are no violation. It's just to try and fix the further problems with her breathing. ACPO January recalls that he discussed the fact that he had email communications with undersigned counsel, which appeared to upset Judge Macarthy-Neyman. When ACPO January mentioned that his email favorable to the defense was likely attached to the motion file for relief, Macarthy-Neyman abruptly left ACPO January's office. There was no legal justification for the court visiting his office and conducting its own investigation outside the presence of defense counsel, off the record and without subsequently disclosure to the defense. So, this judge, who we already knew was kind of sus with the way she acted in the hearing, even though the Supreme Judicial Court said, nah, it's fine. She did her own investigation into a probation matter in a case that would most likely not even give Kelsey Fitzsimmons prison time. Yeah, that seems really sus. And she didn't disclose it to the defense, because if she wanted and go and talk to the parole officer, she can just alert the defense and the prosecution and say, hey, I want to go check this out. Well, then you have to have these parties there because they need to know what was said at this meeting. This is, I think this is highly inappropriate, and this, I've never heard about that before. She went to probation the day before she put Kelsey back in jail. Yes. The day before he was hearing the motion to change the scram device, she goes to the probation officer who gives her the message, there's no violations, which will be in the emails attached to the exhibits. That made her mad and made her leave. This to me also shows this is a highly volatile, emotional judge, which is not a good look. A judge should be kind of level-headed. If she gets angry because the probation officer is just doing his job, he can't withhold evidence from the defense. And just because it helps the defense, she can't get mad at him. That's very unlikely. Well, it's not only when you mock me about my dyslexia. It's also Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday. I do it. Every morning I get out and said, not today, Satan. Zach, leave me alone. I hope this doesn't make things worse for Kelsey. They are asking the judge to fuck off. And I think her running to the probation officer, that seems very, very improper. These ex parte communications concerned matters bearing directly on the defendant's liberty, which was at stake unbeknownst to the defendant. The very next day, such conduct directly violates Rule 2.9 prohibiting ex parte communications, where a judge receives information outside of the adversarial process and then presides over related proceedings. the appearance of impartial adjudication is irretrievably lost. Personal embroilment with probation and defense counsel. Undersigned counsel was recently informed that following the September 11 hearing on the emergency motion for relief, Macarthy-Neyman filed a complaint against ACPO January arising from this case. This is despite her unclean hands engaging in ex parte conversations with probation officers. What? Upon information from ACPO January's attorney, the complaint filed by Macarthy-Neyman includes accusation of defense counsel colluding with probation. As a result, defense team members are now supporting witnesses for ACPO January against the judge in this complaint that directly stems from this very case. What? Where's the kid when I need her to tell me, no, this is just normal. That happens all the time. So she... What? Holy moly. What the hell? As a result, the complaint itself is a strong evidence of the court's actual bias against undersigned counsel and or Ms. Fitzsimmons. At a hearing at the ACPO January probation matter, undersigned counsel would attack this court's position and credibility and assert that the court's complaint is false, baseless, and merely dissatisfaction with an undesired viewpoint from probation. In fact, counsel would also assert that ACPO January at all times acted fairly, truthfully, and professionally. Mr. January did everything he could to accommodate Ms. Fitzsimmons' disability, unlike the court itself, and deserves praise and the full support of the probation department rather than assault on his reputation. Further, this court's complaint is proof that the court's foray into ex parte investigations before the hearing simply didn't produce the desired information and resulted in the court vilifying ACPO January the next day at September 11 hearing without any cause whatsoever. In addition, or perhaps most compelling for recusal, the fact that the judge did not disclose this complaint to counsel for Ms. Fitzsimmons is strong evidence of the judge's bias and lack of impartiality. I said it when we talked about Delgado Garcia. Delgado. I can't remember which one is first. What the hell is wrong in Massachusetts? What the hell is wrong in Massachusetts? First, a judge runs to the probation officer to try and find some dirt. He doesn't get it. She gets pissed off, storms out. Then the next day in court, because she already knows she's not going to get what she wants from the probation officer, she comes in, starts just pounding the table and yelling at defense counsel and the probation officer and storms off and just sends a woman to prison. It's jail. I don't give a F. Behind bars. Because she apparently is just pissed off. That's not justice. This judge should be removed. She clearly is incapable of in any way act as she can be impartial. Running to the probation officers to try and figure out, and then claiming that defense counsel and the probation officer were colluding. What the hell? A judge who has entered the fray, particularly by leveling accusation against counsel of record and court employees who provide good faith assistance to defense counsel, cannot thereafter preside without creating an appearance of partiality. The court must recuse. Outstanding questions created by the court's conduct. Based on all of the foregoing, many questions has been raised that create a scenario where the judge's impartiality might reasonably be questioned. Answers require an evidentiary hearing to obtain facts that would likely show that her impartiality is compromised. The questions are including but not limited to the following. Is the judge related to Patrick McCarthy-Newman? Why is the judge covering every hearing on this case through the trial? Is there a written order to that effect? Why did she repeatedly leave a civil session to cover this matter? What specifically is her complaint to the probation department concerning ACPO January's actions? Why didn't the judge disclose the existence of a probation complaint involving the defense on Ms. Fitzsimmons' own criminal matter? Why did the court have an ex parte meeting with ACPO January in his office? Why didn't the judge disclose the meeting and comply with the Code of Judicial Conduct? Did the judge use any inside information obtained against Ms. Fitzsimmons? Why is defense counsel advocacy perceived by the court as manipulation or collusion? Why is the court using such descriptives which are indicative of bias? Cumulative effect. The SJC has repeatedly emphasized that recusal analysis must consider the totality of the circumstances, even where individual factors might not compel disqualification in isolation. Their cumulative effect may do so. Here, the combination of negative pretrial findings, a personal economic interest, ex parte communications against defendant and counsel, prejudicial findings, and personal entanglement with probation and counsel would leave any reasonable member of the public to question the judge's impartiality. Public confidence in the judiciary requires recusal. Relief requested. Wherefore, the defendant respectfully requests that the court grant an evidentiary hearing, order the recusal of Judge Macarthy-Neyman, reassign the matter to a different judge by a means of reassignment not involving Judge Macarthy-Neyman, and grant such other relief as justice requires. I don't think that personal info, blah, 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 really gave a good ground other than another judge had recused. But the judge running to the probation officer, and when the probation officer didn't give her what she wanted, she filed a complaint against the probation officer. So the defense, who is colluding with the probation officer, is now a witness to prove that they're not colluding with her because this judge lost her mind. What the hell? It really can't be that hard to figure out how bad Massachusetts is. Bradel is a good lawyer. I can't remember the name of the female lawyer. She's also a great lawyer. The one with the long gray hair. But again, Lady Justice must be blind. These are the rules for any Western court system. Lady Justice must be blind. She's not only just peeking under the cover, she's putting her hand firmly on the scale to try and convict Fitzsimmons. Is colluding a crime a justifiable offense? I don't know. That has to do with union rules and everything. It could be that it's just 6 weeks of vacation with pay, just like you'd get in the Karen Reed case if you lose your bats, your gun, your company car, and your leaf blower. This is insane. Poor Kelsey. thank you so much, Masa, and all the other people who have done fundraisers for her, because she needs the best defense she can get, because the justice system isn't blind. The justice system isn't fair. The justice system. Also, why leave civic cases to go there? Was she ordered to do it, or did she just choose to do it? Yeah. But just to end it off with the charges. Thank you, J7, for sending these to me. The charges against Sergeant Jennifer Penton, involuntary manslaughter, causing serious bodily harm, injury to a person participant in a training program involving physical exercise, and perjury. Trooper Edwin Rodriguez, involuntary manslaughter, causing serious bodily injury to a person participating in a training program involving physical exercise. Trooper David Montanes, involuntary manslaughter, causing bodily injury. Trooper Casey Lamont, involuntary manslaughter. But they can just show up in court. They're not going to be driven there by the popo. Rough day from MSP Sergeant Jennifer Penton. AG Andrea Campbell just announced she is being charged with involuntary manslaughter and lying to a state grand jury in the death of MSP Cadet Enrico Delgado Garcia. Turns out in 2023, a few months before Garcia's death, she handled the incident report on Sergeant Scott Quigley, who was allegedly driving drunk when he killed a 34-year-old disabled man in an MV accident, a motor vehicle accident, in Woburn. Here's a report. Didn't interview Quigley for 8 days. No mention of his toxicology report. 0.11 BAC, which he disputes. I'm not the guy to tell you that you better get your torches and your pitchforks out. But you should get your torches and your pitchforks out. What the hell is wrong with Massachusetts? I'm sorry. What the hell is wrong with Massachusetts? You once were the ones who started a revolution over, what was it, 5 cents on a pound of tea. And now you get anally raped almost daily by your politicians, your police officers, your judges, and you just smile and say, well, it can't be that bad. Demio, there's something wrong with the water in Massachusetts. I think you have more lead in the water than they have in Flint, Michigan. I wanted to read this just to see what's in it. First, we then got the Delgado Garcia, at least some justice for him. If it's true that LTL had a video of that, maybe now is the time to release it. I know the family was angry about some of the things he did, I believe, was the reason why he said he didn't show it. But now that the story has changed, that it wasn't an accident, we might be able to see that video. And then on to this. I thought first this was a weak cradle riding with she lives there, so she has a financial burden, blah, 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 blah. I thought that was pretty thin. And then you find out that she's running around doing her own investigations, getting pissy every time anyone doesn't give her what she wants. This is highly inappropriate. Highly inappropriate. Most likely, she will not recuse herself. All I can say is Deitch for DA in 2026, because at least that's something that'll change. Yeah. I don't know. It's 10:15. I'm tired. I'm going to go to bed and yell about Massachusetts. You all go yell about Massachusetts, wherever in the world you are. And when your neighbors say, "Are you weird?" you just say, "No, I am enraged." Everyone, thank you so much for hanging out with me for this part of the day. And I'll see you later. Bye, y'all.
I'm Jimmy. How y'all doing?
I know English is your second language, but you don't word
It's
your
my
questions
third,
carefully.
but I'm still better at it than you. You are
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.